Yes, well, welcome to this session. I'm going to start my timer here. So this is a case that is kind of near and dear to my heart. Of course, I have Ruth right here watching everybody too. So this case does involve Ruth Bader Ginsburg, but as you'll find out as I talk about, she did not actually argue this case. But she has her fingerprints all over it. And the case that I'm talking about is the Craig v. Boren case, 1976. It is a case that went all the way to the United States Supreme Court that, funnily enough, involved Oklahoma liquor laws. And she found it endlessly funny that the Supreme Court would take notice of a liquor law case above any other case that the ACLU was presenting at that time. But this session on the basis of sex, Craig v. Boren, 429 U.S. 190, 1976, or Justice for Beer Drinkers. Justice for Beer Drinkers or Beer Drinkers Rejoice was a headline that appeared in many newspapers throughout the country during the time, especially after the ruling on Craig v. Boren. But to start out with, we have to look at the history. Oh, my screen did not. There we go. We have to look at the history of Oklahoma liquor laws. And if you are a beer drinker, alcohol drinker here in the state of Oklahoma, you probably know that we have a very long and difficult history with alcohol. It has taken us until very recently to update our liquor laws, in fact. Now, when Fred Gilbert, who would be the attorney for the defendants that argued before the Supreme Court, is talking to the justices, he actually mentions in the transcript an 1890 piece of legislation. Now, I will be fully transparent in this and say that I don't know what piece of legislation actually says the legal age for beer drinking because it does not appear in the origin laws. And it doesn't really appear until legislation back into 1933 when we repealed prohibition. So where the legal ages came from, I have no idea. But what he is talking about is the origin laws, the Oklahoma statutes of 1890. And we have some very specific liquor laws that are put on the books at this time. And I have them listed here. You cannot serve on a jury if you sell alcohol. You cannot serve alcohol to a Native American. So this, of course, is applying to the Oklahoma Territory side of things and not the Indian Territory side of things. You cannot be drunk in a public place. You cannot serve alcohol to a minor. You cannot serve alcohol to a known pauper. That also applies to known debtors. So if they're in debt or if they're a pauper, you can't serve liquor to them. And you also cannot serve alcohol on a Sunday. This is also known as a blue law here in the state of Oklahoma. And blue laws really had to do more with morality than anything else. We also have a long and complicated history with blue laws here in the state of Oklahoma. Things like you can't wrestle on a Sunday. You can't watch sports on a Sunday. You can't gamble on a Sunday. And even though we have blue laws at a state level, many municipalities would also add blue laws to their books. And some of them are probably still there, to be honest with you. But at some point, the state of Oklahoma puts the legal age for purchase for men at 21. And that is across the board, no matter what. For women, at the age of 18, you could buy a 3.2% ABW beer. At 21, you could buy all beer, wine, or liquor stronger than 3.2% ABW. And then this photo is, I think it's an actual photo, but this is a drawing from the Oklahoma Publishing Company collection of them pouring beer down a drain in 1907 when we became a state. And it kind of cracks me up that there's like children right here at the front dumping it into the drain. So as we go into actual statehood, we have a big argument on our hands. Are we going to be a wet state or are we going to be a dry state? And the person really behind all of the legislation that has to do with alcohol is Charles Haskell, who becomes our first state governor. He would argue for the banning of liquor, but you could buy liquor for medicinal purposes. He did believe in you going to a pharmacy to buy liquor to heal yourself. So that is something that they did at that time. But during the 1907 statehood constitution, they include prohibition across the board in our state constitution. Article 27 actually initiates the Oklahoma Alcoholic Beverage Control Board. That's repealed in 1984. And then Article 28 actually has the Alcoholic Beverages Laws and Enforcement Act, and that's revised in 2016. So, like I said, we have a long and complicated history with alcohol here in our state. And it's really interesting to try to research this because even though we have the original wording for our Constitution online, a lot of the stuff's been repealed and it has been replaced with new language. So trying to find this, you actually have to go back to the source materials. And in fact, we actually add a completely different amendum to the end of our Constitution. Oklahoma, for the longest time, until Alabama recently took the title, we had the longest state constitution in the United States. And it wasn't good enough for them originally, so they added a thing on the very back that was just for the sale of alcohol. So that's tacked on to the very back of it. Now, we go into full prohibition with the 18th Amendment, and Section 1 states, after 1 year from ratification of the Articles, the manufacture, sale, or transportation of intoxicating liquors within the importation thereof into or the exportation thereof from the United States and all territories subject to the jurisdiction thereof for beverage purposes is hereby prohibited. So you can't buy alcohol to consume and enjoy. Now, it says for beverage purposes, medicinal was still on the table. So you could go to the pharmacy and still buy liquors to heal yourself with. But this is repealed by our 21st Amendment in 1933. Section 2, the transportation or importation of any state or into any state, territory, or possession of the United States for delivery or use therein of intoxicating liquors in violation of the laws thereof is hereby prohibited. We do not ratify the 21st Amendment. So Oklahoma's still debating, are we wet or are we dry? We do not ratify the 21st Amendment, but we do have a piece of federal legislation passed known as the Alcohol Beer Act of 1933. And this goes through the houses of Congress and the Senate in June of 1933. And this is an act to legalize the manufacture, sale, or possession of 3.2% beer in the state when and if the same is legalized by a majority vote of the people of Oklahoma or by an act of the legislation of the state of Oklahoma. And then we get into the argument of the wets versus the dries. Do you want a wet state? Do you want a dry state? The wets are arguing that we have just gone through a depression. We have gone through an economic downturn. We have been dealing with the effects of the Dust Bowl. We need an economic boost. So we're arguing for increased revenue during economic downturn if prohibition was repealed. So that's what we're arguing for. And the dries will argue that no, if you introduce alcohol, there's a higher crime rate and we're going to have more people in jail. You will find through this entire case that many of the main points are hinged upon morality. Will we become less moral if we allow alcohol to happen within our boundaries? But we do actually pass the Oklahoma Beer Act of 1933, and that is when those the ages actually get solidified. We create the Able Commission, April 7th, 1959. Prohibition is officially repealed by House Bill 829, or 825. The Alcohol Beverage Law Enforcement, or the Able Commission, is officially formed. So you can now sell 3.2% alcohol by licensed retail stores at room temperature. So you can't sell it chilled, it has to be room temperature. 3.2% beer could be sold by any establishment with a beer license and would be regulated by the Able Commission. So we brought bureaucracy into it. We can have liquor, but the Able Commission is going to control everything. And then we have a 1976 Oklahoma Supreme Court decision, and this is mostly to do with our distribution laws. Oklahoma distribution laws are called into question. What had been happening was distributors were actually distributing liquor all throughout the state, and that was a big no-no. They wanted them to stop doing that. So franchising among distributors is illegal under the liquor law, so you can't franchise anymore. And in fact, many major domestic brewers discontinued selling strong, quote-unquote, strong beer in the state until 2010. So I know a lot of people, I was in college in 2003 to 2006, and my friends and I would go over the border to Kansas or Missouri or Arkansas to get our High Point beer because at this time, they couldn't sell it in the state of Oklahoma. But at the same time as all of the legislation that is going on around, I heard some people clapping. All of the things that are happening in the state of Oklahoma with our beer laws and our liquor laws also coincide with what's happening with the Equal Rights Amendment, the ERA. So we pass the 19th Amendment here in the United States, which gives women the right to vote. The suffragettes, the super famous women all in white who were protesting for our rights. Oklahoma was actually ahead of the game. We did it 2 years before that. So that was codified in 1918 here in the state, but in 1920 they do it for the rest of the nation. But in 1921, the National Women's Party realizes that there are gaps in the 19th Amendment. So we've got the right to vote, but does that apply to everything? Where is the equal rights across the board for everybody? So September 25th, 1921, the National Women's Party creates an amendment for the U.S. Constitution that will close the gaps in the 19th Amendment. The person who they employed to do this is Alice Paul, who's a really famous suffragette. In fact, the language she writes in 1921 is still what is in the amendment today. And she crafts this Equal Rights Amendment using the 19th Amendment and the 14th Amendment. She uses the language of both. Because at this time, we are using the 14th Amendment to rule on things that have to do with race. And we want the same thing that we can do with gender. So what you'll find is that they are looking for what we call the test, the quote-unquote test. What is the test for gender? So we have the 3 sections of this Equal Rights Amendment. Section 1, equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. Section 2, the Congress shall have the power to enforce by appropriate legislation the provisions of this article. And Section 3, this amendment shall take effect 2 years after the date of ratification. So by 1971 to 1972, we have actually put in enough work that the ERA is heard before both houses, and it's approved. It is actually approved and sent out to the states for ratification. And again, if you're wanting to ratify an amendment, how much do you have to have? 2/3 votes. So we have sent it out to the states for the 2/3 vote. One of the biggest proponents here in Oklahoma was Wanda Jo Peltier, who is in the photo right there. You might recognize her. But the ERA fails. It is never ratified. 38 states ratify it. 6 later revoked their ratification. And the ERA, the last being Virginia in 2020. So it's still in the books in many states. We've just never gotten around to ratifying it. They get real close to that 2/3 majority, but they don't actually get there. Oklahoma hears the ERA, and the state Senate voted to ratify it on March 23rd, 1972, but it's only by a voice vote. And that's it. That's it for the state of Oklahoma. So here in Oklahoma, we have liquor laws combined with Equal Rights Amendment. And this is all happening in the early 70s when we have the ACLU step onto the scene. And the ACLU, the head of the Women's Rights Project at that time, was Ruth Bader Ginsburg. This photo down here is a photo of her at her hearings to become a Supreme Court justice. But at this time, she is a lawyer working for the ACLU. And with the failure of the ERA, the ACLU is looking for that case that would set the test that they wanted. So the first case that Ruth Bader Ginsburg ever argues in front of the Supreme Court is Frontiero v. Richardson in 1973. And they thought that this case was pretty good. Lieutenant Sharon Frontiero was seeking housing and benefits for her husband, whom was her dependent. So she is in the military. Her husband is her dependent. And so Ruth Bader Ginsburg is arguing that we have a discrepancy here based upon gender. So she will admit in many of her writings that she was very, very nervous when she was arguing this, her first big case in front of the Supreme Court, but she went at it. And she argues that there is what we call strict scrutiny. That is the test of the 14th Amendment. So she argues that strict scrutiny was introduced for discrimination based upon race should also be applied to all acts of discrimination. So not just things based upon race, but things based upon gender as well. She also argues that the language of the 14th Amendment refers to any person. Doesn't specify man or woman, it is any person. And Ginsburg believes in the power of language. She is a very great wordsmith. She uses specific language in her briefings, and that is specifically on the basis of sex. So where we have the Equal Rights Amendment, that first section, on account of sex, that was what was written originally. She will not let her secretaries use the word gender. She said it's too neutral, it's too sanitary. And in fact, one of her secretaries comes up to her during these many cases and says, all you see on this page when you look at it is sex. Sex, 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 sex. And Ginsburg's response to that was, well, maybe an all-male judicial panel will pay attention then. So she insists that sex be the word that is in there. It's more inflammatory. It's more of a response. But what happens in Frontiero v. Richardson is that the gender issue is not argued. In fact, the Supreme Court justices just kind of ignore the gender issue altogether. They rule in favor of Frontiero. They say, yes, you should be able to carry your husband as a beneficiary, but this has nothing to do with the fact that you're a woman. And so they don't get their test out of Frontiero. And so now they cast their net far and wide, and they are looking for another piece of legislation to take before the Supreme Court. And they end up in Stillwater, Oklahoma, of all places. This store is the Honk and Holler. It is no longer the Honk and Holler. The building still exists. You can still see it in Stillwater. But this is the Honk and Holler. It is just off the historic Strip in Stillwater. Have any of you ever gone drinking late night on the Strip? Would have never. That's what we told all of our parents in college. He's learning all kinds of things today. So the Honk and Holler is an alcohol establishment. They sell alcohol. And the whole reason why it's called Honk and Holler is because you drive up, you honk your horn. Carolyn Whitener, who owns it and has owned it since 1962, would come out, take your order, go and get it, and bring it back to you. So you pull up and you either honk or you holler, and Carolyn would come out. So that's why this is called the Honk and Holler. And this is actually a joint venture between Carolyn and her husband, but her husband had lost his liquor license. Now, it's never explicitly stated in any of the oral histories that I have listened to from Carolyn, but her husband lost the liquor license because of the age discrimination. He was selling beer to underage men. So we consider underage. They're under 21. They're not 18. So he had lost his liquor license. So her name is the only one on the liquor license at the Honk and Holler. In 1972, Mark Walker approaches Whitener about participating in a project. Now, Mark Walker is a Lambda Chi Alpha fraternity man. So he's a college student. He's under the age of 21. He has had to get his sorority sisters to go buy him alcohol many times. And he's in a poli-sci class at OSU, and they're talking about the ERA. And in the midst of talking about the ERA and the state's liquor laws, the professor has heard enough complaining, and he tells Walker, unless you do something to change the law, you can no longer complain about the laws. And so Walker starts a project, and he walks up and down the Strip, and he becomes really interested in the Honk and Holler. Why? Because Carolyn's name is the only one on the liquor license. And so he talks to Carolyn, and he says, would you be interested in becoming part of a project? And that's all he really says to her. And she says, sure, why not? I'm too busy to really care about this. And so Mark Walker and his Lambda Chi Alpha fraternity brother, Curtis Craig, hire the cheapest lawyer they can find in Tulsa. They pool their beer money, and they go to Tulsa, and they hire Fred Gilbert to file suit against the state of Oklahoma, which is how we get the Boren in Craig v. Boren. Boren was the governor at that time. So they file suit against the state of Oklahoma. And they are alleging that it is discriminatory against men for you to not sell us liquor before the age of 21. That's all they're arguing amongst the state filings that they do. But Gilbert thinks that their best chance at winning this suit is to partner with someone or an establishment that sold alcohol. So here comes Carolyn Whitener. Carolyn Whitener is unaware that she is a defendant on this case. She does not find out until her husband, and she states that she had a very quote-unquote traditional marriage. Her husband was the head of the household. He was a very gruff person. He had very German values. And she said that he is in the Carolinas and calls her and he says, what the hell is your name doing on this piece of legislation? And that's when she discovers that she is a defendant in this case. And she said it actually caused an argument in her marriage. Her husband was completely against it. He did not believe that they should participate in this. But she said she had an epiphany. She had picked him up from the airport in Oklahoma City. They were driving home, and she told him that she was going to be part of the case. She felt that this was important enough that she wanted her name attached to it. So they start going through all of the different courts here in Oklahoma. Ruth Ginsburg, she was delighted. Delighted to see the Supreme Court is interested in beer drinkers. That's an actual letter she sent to Fred Gilbert when she first met him. The first arguments of Craig v. Boren would begin in 1972. The district court rejects any discrimination allegations. They say nope. And it says a valid exercise of the state's power pursuant to the 21st Amendment of the United States Constitution. So they file an appeal. The first appeal is heard in 1974, and it's heard by a 3-judge panel. And this cracks me up because this explains the state's logic into why they're not going to repeal this. Instead of explaining the legislation's original intent to retaining this age-sex differential in the beer law, the state offered a traffic safety justification. Relying heavily on statistical evidence, the state argued that more males than females between the ages of 18 and 21 were arrested for drunk driving and were injured or killed in traffic accidents. It's a morality clause. Females are more responsible. If we repeal this, we're going to be scraping more males off the highway when they get drunk. So then they elevate it again. And by the time this has gone through our 3-panel judicial hearings and everything, that's when the ACLU hears about it. And Ginsburg sees a chance with this case. And she steps in and she starts to counsel Gilbert on how to take the case to the Supreme Court. She starts to craft the argument behind this. And this is a photo taken well after Craig v. Boren. But this is all of the people together. So you have Ruth Bader Ginsburg, Carolyn Whitener, Fred Gilbert, and Curtis Craig. All are still alive with the exception of Ruth Bader Ginsburg. So, yeah. And they call this the Trojan horse. This is the Trojan horse case. And Ruth Bader Ginsburg loved this case. And why did she love it? Because we're talking about men's discrimination and not women's discrimination. So the ACLU actually files a brief to the Supreme Court. They have no dog in the fight, but this kind of brief basically states that we feel there's merit in taking this to the next level, and the Supreme Court agrees to hear the case. So ACLU's there, they're not directly involved in it. Fred Gilbert will be the person that stands up and actually argues the case in front of the Supreme Court, but Ruth Ginsburg is there kind of crafting it. She's telling him what to say. So Gilbert argues that if the only reason sex has not been treated with strict scrutiny, the 14th Amendment test, was because of organic differences between the sexes, then why not apply strict scrutiny in cases like this one, where the discrimination had nothing to do with those biological differences? We're not talking about biological differences, we're talking about age. And because of this, you have to understand the law is inherently discriminatory. Now, if you go and look it up in the dictionary, like I did today, we base it on gender, class, things like that. That's what the definition of discrimination is. But the second definition is the recognition and understanding of the difference between one thing and another. This is the second definition of discrimination. So the law is inherently discriminatory. We're going to discriminate no matter what. That is their purpose in hearing this case. But we have a few problems. Walker was now above the age of 21 and had actually passed away. And of all the things Walker passes away in, a car accident. It has been said that it was a drunk driving accident, not him drunk driving, but he passes away in a car accident. So that's not helping their case any. The state has already argued, we're going to have more car crashes if we allow men to drink. Curtis Craig turns 21 10 days before the case is argued before the court. So he has to leave the case because he's no longer being discriminated against. So Whitener stands as the only defendant. And she continues to just say that I believe in this case enough that I will keep my name on it. So with her as the defendant, Craig v. Boren goes before the Supreme Court. Opening arguments commence with Fred Gilbert arguing the case, and Ginsburg stands with the parties. So she's there standing, she's not there arguing. And the justices have a field day with Gilbert. It is a slaughter. It is a complete slaughter. In fact, at one point, Justice William Rehnquist refers to Whitener as a tavern keeper in the oral arguments. Not only that, but Gilbert constantly interrupts the justices, which is also a no-no. So there's all this going back and forth. Whitener said when she heard the term tavern keeper, she referred to it as the barmaid, quote. And she said, I wanted to stand up and ring him a new one because I am not a barmaid, I am not a tavern keeper. But anyway, Gilbert makes his argument in line with what Ginsburg had advised. And this is an actual quote from the transcription. William Rehnquist states, well, has the court ever held that discrimination of this sort is the same class as discrimination based on race? And Fred Gilbert said, Your Honor, the court has come very, very close. But very, very close was not good enough for the justices. So they rest their case. And Whitener said she knew they had lost at that point. She knew in her heart they had lost. But then comes the notorious RBG. She is arguing a case that afternoon in the Supreme Court. And nobody knows how she gets this case on the docket in the afternoon. But many people also refers to this as the hidden Trojan horse. So we've already got that little Trojan horse in the door, and it didn't go so well, so now we've got the second Trojan horse. And she's arguing a case known as Matthews v. Goldfarb. And this is a Social Security Administration case in which a woman is holding her husband as a dependent. So another case like Frontiero. So we have woman holding her husband as a dependent. So it is a sex-based piece of legislation. And Ginsburg is the lead lawyer on this case, and she is presenting the arguments. Now, during her arguments for Matthews v. Goldfarb, the justices interrupt her and start asking her about Craig v. Boren. And the first one to interrupt her is Justice Stevens. And this is the complete transaction between the two of them. Whitener would state that, Ruth Bader Ginsburg was a tiny little woman, but she stood her ground. She never let them push her around. Justice Stevens says, we heard a case this morning, just to be concrete, involving a law that would not permit males to make certain purchases that females could not, or could make. And it was attacked as discrimination against males. My question is whether we should examine that law under the same or a different standard than if it were discrimination against the opposite sex. Ruth Bader Ginsburg said, my answer to that question is no, in part because such a law has an insidious impact against females. It stamps them docile, compliant, safe to be trusted. Stevens, but your answer always depends on their finding some discrimination against females. Is that your view, that there is no discrimination against males? And RBG said, I think that there is discrimination against males. Stevens said, and if there is such discrimination against males, is it to be tested? Test, there's the test. Is it to be tested by the same or by a different standard from discrimination against females? Ruth Bader Ginsburg said, my response to that, Mr. Justice Stevens, is that almost every discrimination that operates against males operates against females as well. Stevens, is that a yes or a no answer? I just don't understand why you're trying to avoid the question. And she said, no, I'm not trying to avoid the question. I'm trying to clarify the position that I don't know of any line that doesn't work as a two-edged sword. So she takes this beer law fight, and she crafts it in a way that it's not a female being discriminated against, it's a man. And a justice who, on an all-male panel, can relate to that. On December 20th, 1976, the Supreme Court issued their decision on Craig v. Boren. On a 7-2 decision, finds that Oklahoma's statute is unconstitutional and in violation of the 14th Amendment Equal Protection Clause. Carolyn Whitener was working at the Honk and Holler that day, and she said the reason she found out was because a reporter called her, and then immediately after that, Curtis Craig calls her and says, we're having a party down at the fraternity house. You want to come drink some beers with us? And she said, I politely said no, and I continued about my day. And what this does is it creates what we call the test for gender suits across the nation, and it is known as intermediate scrutiny. So we have strict scrutiny with the 14th Amendment, but with this one we get intermediate scrutiny. And intermediate scrutiny is higher than rational basis, which is the lowest review standard in law, and less than strict scrutiny, the test used for racial discrimination. So to pass in intermediate scrutiny, a case must, Further, an important government interest, lower burden than compelling state interest required by strict scrutiny test. It must do so by the means that are substantially related to that interest. The legal age of consumption was lowered to 18 until the 1980s when we raised it up nationwide back to 21. So it only lasted for a little while, but we did win. Oh, that's my alarm. We're almost done. We did win the case, and we created the intermediate scrutiny. And at one of the retrospectives that was done at OSU, Ruth Bader Ginsburg could not attend, but Curtis Craig and Carolyn Whitener did attend. And Carolyn was given this very nice note from Justice Ginsburg, and it says, "Dear Carolyn, as I told you in 1996 when we celebrated the 20th anniversary of Craig v. Boren, you are the true heroine of that case. Although no financial gain was at stake for you, you realized the potential the case had in paving the way for the court's recognition of equal citizenship stature of men and women as constitutional principle." And when Ruth Bader Ginsburg passes away in 2020 at the age of 87, of course, she goes on to an illustrious career. She becomes the second Supreme Court justice that is female to be appointed to the court. The piece of legislation that is most often cited for her obituary is Craig v. Boren, and is most often seen at the very end. So that is it for this session.